While they go over that audio, let's bring in our guest for this hour, national trial attorney Michael Jaafar. Michael, Jenna is really emotional on the stand. Just looking back at those images seems to be really difficult for her. Your thoughts on it? The defense is going too far. I mean, she's not a witness that anyone is pointing the finger at. She's someone who went and got the kids away from this scene. What do you think about the tone that the defense is taking?
I don't like the tone that this defense attorney's taken. I know he's not the main attorney in the defense. He's chair too, but I don't like the tone he's taking. He's attacking her, which is just weird and bizarre. He's sitting next to a client who has some legitimate defenses to the case, but he's attacking this woman. She's crying. She should be answering his questions, and I understand that he wants answers to the questions, but he seems like I think he's watched too many law movies and thinks that the way to have an impact in a courtroom is to attack somebody and make them cry. This is the type of a cross-examination you would have if you were doing a mob defense, and then the witness on the stand is a person wearing an orange jumpsuit, and you are basically telling that person, hey, aren't you a pathological liar and a murderer? That's the type of cross-examination style that he's following. But this cross-examination style does not play to a jury, and it does not play in this type of a situation, because the witness on the stand is a very eminently sympathetic person. This is a person you need to coddle, and by the way, you'll get more with honey than you do with vinegar. I'm telling you right now, folks, when you're in front of a jury, do not make a witness like this cry. You don't help your client, you hurt your client.
That's a really good point, because we're even seeing, it seems, more tears on cross than we did on direct. Let's go back in. I'm getting word that the jury is there. Let's go in live. Let's bring in national trial attorney Michael Jaafar. Michael, this is an important witness. He's the alibi witness for the son that the defense has pointed the finger at. Is this an airtight alibi?
I think it's a good alibi. He seemed pretty credible. He seemed pretty, I mean, I liked him. I believed him. I think he's a pretty airtight alibi. At the end of the day, the defense want to add as many options as possible. Obviously, they're going to point the son at they're going to point their finger at the son. Obviously, they have some good defenses when they take their case. They're going to say there's no way, if it wasn't a son, how was she going to carry a 300-pound, over 6-foot tall person from the house to the burn pit? He started the burn pit himself. I mean, so they have some defenses, but he's an airtight alibi. It's circumstantial, but I think it's a pretty good alibi that the finger should not be pointed at the son. I think the jury is they're going to like this witness just like they liked the witness before him. So I think it's a pretty good alibi. It could have been better, right? Obviously, I always prefer video evidence of an alibi, but this is circumstantial. It's the best that you can get.
Yeah, he wasn't 100% sure about the timing. Said it was late, said it was after he went to sleep. So maybe if there's cross of this witness, they'll bring that up, but we will see. Also, I want to ask you about the way that this victim died. We've got the autopsy report took a year before they could conclude that it was a murder. And I think it's probably going to be difficult for them to pinpoint a time of death. Does that muddy things up when it comes to an alibi?
I think it was October 3rd that he started the burn pit.
July 3rd.
People over, July 3rd, sorry, that he started the burn pit. And then he had people over, and then he was found dead the day after. So the timeline is going to be all over the place. Listen, I like the opening statement of the prosecution. They said, you need to shrink your world and you need to just look at the following facts. She had the motive. She was there. She was the only person who was there. She committed this murder. I'm not saying they're right. I'm saying that they have basically ossified the minds of the jury to say, this is your person. She's sitting in the court right now wearing very expensive clothing and pearls, and she had every motive. She even said, I hope he had a gruesome death, right? So they're gonna
2 years before, Michael. 2 years before she said that in a rocky marriage.
No, I know. I'm just saying they're gonna paint her as a villain. This is a villain type style prosecution. They want to paint her as a villain. I don't know if she's done herself any favor, but at the end of the day, the circumstantial evidence does show that she hated her husband, right? So whether or not the prosecution is going to overcome this, I'm really interested in seeing how the defense comes out, and really interested in seeing the closing statements. But in terms of the timing of the death, they're not going to be able to say this was the exact time of death. This case has a lot of circumstantial evidence against her, circumstantial evidence in her favor. So it's going to be a challenge one way or the other.
Means, motive, opportunity. Prosecutions have been won on that and less.
Yes.
Michael Jaafar, stand by. Coming